We are live.
Well, good afternoon, everybody. Thank you so much for being here at this State Supreme Court Justice. Getting nice. Turn it off a little bit. Turn it up. Where's my sound guy?
Thank you, Jane, for the opportunity to do the invocation. Fortunately, the Bible gives us great insight and teaching on wisdom, discernment, courage, and just judging. And I was struck by the timelessness and timeliness of that wisdom. It seems so applicable to the current state of our affairs in Washington State. Just give you one quick passage in the interest of time from the book of Judges, not surprisingly, chapter 2, where God raises judges and has hearing and mercy for us. And the Lord raised up judges to deliver them from the hands of those that oppress them. But they would not hearken to them, committing fornication with strange gods and adoring them. They quickly forsook the way in which their fathers had walked, and hearing the commandments of the Lord, they did all things contrary. And when the Lord raised them up judges in their days, he was moved to mercy and heard the groanings of the afflicted and delivered them from the slaughter of their oppressors. So, Heavenly Father, we come before you with gratitude for the privilege to participate in our civic life. God of all wisdom, guide our thoughts and decisions today. Lord, we thank you for the ability to serve our community. Pour out your inspiration and blessings on this forum and on every person within our community. Please bless this gathering and let our work benefit all in a spirit of wisdom, truth, and justice. God, grant us discernment and righteousness. As we convene, may our deliberations be marked by fairness, courage, and compassion toward all. Guide our hearts and minds toward what is right. Please inspire these leaders and participants to devote their time and talents to the common good and to uphold justice with humility and integrity. You see how hearts grow weary and how the good things you call us to may be postponed or neglected. Please help us break through any numbness, apathy, weariness, discouragement, or disconnectedness within the hearts of we voters, especially in moments when voter apathy threatens to silence the voice of your people. Stir up love for our neighbors and a renewed sense of responsibility in our community. Make us instruments of hope so that our actions reflect our convictions and our convictions bear good fruit in Washington State. Help us speak truthfully, live justly, and encourage others to rise up with us. Heavenly Father, grant us renewed passion for justice, the courage to participate, the courage to speak truth with love, the wisdom to understand what is at stake, the grace to care again, and the humility to listen to your wise counsel and work with one another. Replace later with faithful action now and apathy with purpose. May we leave this gathering with clarity, conviction, unity, and a renewed purpose in your service. In Jesus' name we pray. Amen.
Amen. And if you could remain standing, we have Chushcoff is going to come up and lead us in the Pledge of Allegiance.
Beautiful flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, at this time, I know you're anxious to hear everybody speak. I wanted to introduce you to our moderator for the day, which is retired Pierce County Superior Court Justice Bryan Chushcoff. I have known Bryan since '96, I think, and helped him in his early when he first campaigned, and he was a judge for 28 years. So Bryan is running for Pierce County Prosecutor, which is a really important position. Right now, the President Prosecutor did lobby as being somebody in the middle, and actually has proven to not be. Are any of you familiar with that case of that wrestler in Puyallup, the girl wrestler? You guys familiar with that? So a girl wrestler was wrestling against a biological boy, and he sexually assaulted her during a wrestling match in Puyallup last December. Our prosecutor that's in there now refused to prosecute the boy. And so that girl, I don't know all the details, but we need some fairness in the prosecutor's office. And so I really want all you guys to hear why Bryan's running for Pierce County Prosecutor. And he's on the handout that I gave you, and I want you to encourage all your friends to vote for him. And so, Bryan, would you please introduce yourself and tell us a little bit before we get started with talking to the other candidates why you're running.
Thank you, Jim. Again, hopefully everybody can hear me. My name is Bryan Chushcoff. I'm a local guy. I was born and raised here in Tacoma. And I went to local schools with the University of Washington. Got my degree in business administration there. Then I went to the University of Tucson for law school. And I started my own office in the University of Sterling, and then later in South Tacoma. And I had a wide range of practice. We're sort of general practitioners, lawyers that do that actually. All pretty much specialized. It's very unusual in a way. But so I did all kinds of civil litigation, family law cases, all kinds of litigation, which proved useful because as a Superior Court judge, you can do all those kinds of things too. If I had any claim to fame as a private lawyer, I was just going to do several criminal cases, and I represented through the Department of City Council. They would have a conflict of interest for a reason or other, and then they would ask me as a private attorney to handle the case for them.
Can you put a little closer to your mouth?
A little closer now?
Yeah.
So the Department of City Council would ask me to represent the people from time to time. And I was on what's called an A panel, which is Class A felonies, which are one of the most serious kind of felonies. And so in the course of that, I handled several murder cases as a defense attorney. And I won a few of those. And one of the things was interesting. So they got me some sort of riot agents and kinds of things printed in the newspaper. Ultimately, I wound up running for judge, and in 1996 I was running, and at the time I got an endorsement from the Tacoma Police Union. And I found out later that the reason I got it was because there were several of the homicide detectives who I'd been on the opposite side of those cases, who went to bat with me with their membership, and said, hey, this is a smart guy, he's fair-minded, he's going to be a really good judge, we need to get behind this guy. And I have to tell you, there's a certain amount of if you get a little emotional when the people that are the opposite side of you in the courtroom think you're good enough and that they're willing to vote for you and support you. And so that was very heartening. So I spent the next 28 years as a Pierce County Superior Court judge, trying every kind of case imaginable. lots of criminal cases. I did not run for re-election in 2024. Some of you may have noticed I'm kind of an old guy. I'm 74 years old. I just took that birthday year. Under Washington state law, you can't be a judge in the state beyond December 31 of the year in which you attain the age of 75 years. And that meant that if I run for re-election, I could only serve 3 years. And then the governor would get an appointment for my position. I thought, I've maxed out on my pension. I really think that somebody other than the governor ought to be in the position. People have a choice of who my successor is. So I did not run for re-election, and I've been retired for the last year and a half or so. And I have to say I've enjoyed it. But the reason why I'm running is because when I sat in all those meetings over all those years, I just thought, if the prosecuting attorney's office could have any better management skill, this whole thing would work a whole lot better. Now, in the back, I think there's a little piece of paper that talks about the felony problems in terms of filings and pending cases. And so I'm not going to repeat all of that. But there's good management framework. And one of the things that's happened is that with the baby boomer generation, the demographics of that dropping off, and with COVID and so on, sort of accelerated a lot of people's retirement. So a lot of new people in the prosecutor's office, a lot of new people in every agency of government, for that matter. And when they reorganized the office, when Ms. Rob Beckers, the current prosecutor, came into office in 2017, they changed it in such a way that I think was not useful for effective management. That may explain some of the problems that we're seeing. I want to reorganize the office into triumphs that are arranged around particular case types. Now, this is all boring sort of management technical stuff. It's inside baseball. But one of the things that's happened on the other side of this is that the police are also organized that way. They're organized when there's larceny and there's theft and homicide and assault evidence. So if they've lost communication with the prosecutor's office, because the prosecutor's office is not arranged that way anymore, and it needs to go back to that. It would improve the training and mentoring of the folks there, the new folks there, and improve communication with the other folks. So law enforcement has been very supportive of me. So the moment I got the endorsement of the Deputy Sheriff's Independent Appellate Police Association, the Tacoma Police Union hasn't made a decision yet. And Lakewood, I understand, is not going to make a decision, so they're going to stay out. But I think it's interesting that my opponent, who's the chief criminal deputy, is not getting law enforcement support. And acknowledge that there's a communication problem with her office. That she said they've been working on to close the gap for a couple of years. I say it's their responsibility the gap occurred. And 2 years working on it still solid is too long. So, I guess at the end, I would say this. Because I want you to get to the media program here, not me. I do offer sort of deep local roots, decades of experience in this, proven administrative ability. I was a presiding judge for 4 years in Pierce County Superior Court. I was on the executive committee longer than anybody. I was also presiding judge longer than anybody. So I'm running to bring steady, disciplined, competent, accountable, transparent, and ethical leadership to Pierce County government and prosecutor's office. So with that, I'm turning to the reason why you're here, the Supreme Court justices. We're far more important than I am.
Bryan,
Yeah.
you're hard to hear.
Yeah, maybe no microphone?
Maybe no microphones?
Yeah, loud voice.
Well, some of them
Very
are.
distinct.
Well, maybe if I talk from slow,
It echoes in here, Bryan.
Well, yeah, it's the room and the speakers.
then I'll try to speak more slowly. That sometimes helps me.
Yeah, sound system. Bass down.
Scott Edwards is also a candidate for
Which
Washington State Supreme
is
Court.
the
Mr. Edwards could not be
Rick
here
Bauer
today.
is.
He did provide a statement to change his hand from the HDS that I did this program. So I'm going to read this as written here by Mr. Edwards, and so this is not my statement. Statement is below. My name is Scott Edwards, and I'm running for the Washington State Supreme Court. So Edwards, because I believe that our highest court must be a place where the law is applied fairly and thoughtfully as written, and in accordance with the Constitution fair and balanced check to government while protecting our constitutional rights and providing legal justice. From my first job at age 14, working at my grandparents' restaurant, to chairing a legal practice at a major Pacific Northwest law firm, I know the value of hard work. I've been practicing law in this state for more than 30 years, representing individuals and businesses large and small, helping them to understand and pay the taxes they owe, while also helping to make sure that the government applies the law as written fairly, consistently, and in accordance with the Constitution. Throughout my legal career, I've had the privilege of seeing the justice system from multiple perspectives, providing advice, helping to form businesses, and in the courtroom, including more than a dozen Washington Supreme Court cases. I've worked on complex legal matters, studied law carefully, and built a reputation for preparation, professionalism, and integrity. In addition to my legal practice, I have also been teaching in the tax LLM program, master's degree in tax LLM program at the University of Washington School of Law for more than 20 years, where I helped to educate the next generation of lawyers. In the courtroom and in the classroom, I've always approached the law with rigorous reason, common sense, and integrity. I will bring that same approach to this community. I've spent years solving difficult problems, weighing competing arguments, and understanding that good decisions require patience, discipline, and respect for the facts. That experience matters. The role of a Supreme Court judge is to interpret the law faithfully, protect constitutional principles, and treat every person who comes before the court with fairness and respect. My commitment is to protect your constitutional rights and ensure justice and maintain a court that is accountable to voters, one that is worthy of the public's trust. You can learn more about me at votescottedwards.com. Thank you. So then with that, I'm going to ask each of the candidates here to introduce themselves, and I guess I'll do this in alphabetical order. And I'll start that way and ask them to identify themselves and let us know why they're running to be elected justice in Washington. So, Mr.
Speak up. Thank you for that introduction and statement from Mr. Edwards. I was encouraged to run for this board a couple of years ago by a retired judge who was the past president of the Washington State Bar Association, and some of the other members of the state bar. One of the things that so I ran 2 years ago, and I did not make it through the primary, after which time I endorsed my counterpart here, Judge Larson, who was running at the time as well. And I believe that my candidacy resonated with voters, and so here I am again. After that race, I had seen an interview by the Chief Justice who indicated she was concerned about the confidence in polling that shows weak support for the institution of the Supreme Court, courts generally, and the criminal justice system. And when you look at polling, it's actually gotten worse, and it's the confidence and trust in the court system and the criminal justice system has been declining, and it declined something around 20% or more just in the last, basically post-COVID, I believe it was what the polling indicates. And I've been thinking
Might be that microphone, yeah. Switch them.
And I think, we look at the institutional confidence in the court, and I think there's why would we think that there's issues, or why would we think there's issues with our criminal justice system? And so being on the Board of Governors also kind of gives you a little bit of the inside baseball, if you will, so to speak, where, you know, the Bar Association is a subsidiary, essentially, of kind of the Supreme Court. So the bar regulates lawyers, and so if somebody wants to become a lawyer, the bar handles the admission, allowing them to practice or not, if they're not qualified or they're not ethically acceptable. And then also disbars, right? So if lawyers have committed some wrong against their clients, then they can disbar those lawyers. And other than that, so the Bar Association is there for those purposes, but it's also to give recommendations on rules and different administrative aspects of the bar as well. And so from that perspective, you know, some of the initiatives that the bar is in admitting new lawyers and things of that nature, you know, I've been involved with this, and I don't always agree with where the bar is coming from. And so part of that really led me to believe that, you know, I can do so much at this level, but in order to really have a greater impact, I actually need to be at a different level and have this basically the Supreme Court. So that's really kind of an overview, looking at you know, where the court is now, what these initiatives and rule changes and proposed changes to the structure of the bar, and really kind of led me to believe, hey, we need somebody who can pay attention to those things and maybe have more influence on making them more amenable to and beneficial to the state instead of just a specific interest. My background is I've practiced, I've been admitted to practice law since 1992 in Louisiana. I've been admitted in Washington State as well, sometimes since then as well. I'm also a certified public accountant. I'm a chartered financial analyst and a certified public financial planner. So I've had a lot of hard exams, studied a lot of technical and detailed material, and after 9/11, I was called out of the Navy Reserve and spent a little over 10 years on active duty, deployed to the Persian Gulf, deployed to Southeast Asia, the Western Pacific, and South America. I'm not going to plans. But I think that also has shaped my personality, my character, who I am today. I was kind of called like a Minuteman, if you will, of the American Revolution. They were laid outside their plows, their business pursuits to go fight the war, to win our American independence. And so I really identify with our founders. And I had, you know, I mean, as lawyers, everybody swears an oath to the Constitution. But not everybody risks their life or in their fortune, right? And their personal, their honor and their fortune is the founders did, right? And so for me, I think that that's something that the public can look at and say, hey, you know, you didn't just talk the talk, you walk the walk. And I don't hold that against others, but I think that's one thing that also differentiates me as a candidate. But in closing briefly, because I kind of rambled out probably beyond my time, that's a great time, but like Mr. Edwards said, you know, I think as somebody who's had a career that's focused on independence and being independent, whether it's of your clients, financial matters, or things of that nature, but having that objectivity and so the independence, the integrity that's required for service in the country, in the legal profession, and in the other professions that I practice, and in fairness, and applying the law as written and is consistent with the Constitution. Those are really my key things, and the ability to kind of now that I've got those the behind the scenes stuff to be able to have greater influence on the administrative type aspects of the bar and administration of justice. So with that, I'll pass it over to Judge Larson, and appreciate your attention to opportunity to
Can you hear me okay? Okay. So, by the way, Todd and I aren't running against each other this time. He's running for position 7, I'm running for position 5, and Judge Stevens is running for position 3. So 3, 5, 7. So, you know, we end the pledge of allegiance with liberty and justice for all, because you can't have one without the other. The justice system is important to our existence. It's the third branch of government. I always joke, but it should be true, that for the offensive line of the government, we only get noticed when we jump off sides, because we should be the most boring branch. We should be a branch that is dependable. I use the term, we're a lighthouse in the storm, not a ship lost at sea. And when you interpose politics, you interpose all these different things into the judiciary, you become the ship lost at sea. You no longer become that pillar that they need to look to. There's dependable outcomes for cases where you're determining want to be involved in business transaction or whatever you're involved in. You got to predict the law based on what the law says, not on what a particular judge's political preferences are. And so getting the judiciary clear of the politics is very important. Our form of government is designed for people that want to pursue duty and responsibility, not power and control. And the reason we're so interested in getting our way, we've lost our way today, is because it's been about power and control, and the judiciary is not exempt from that. And what we need to do is get the judiciary back to what it's supposed to do. It's supposed to be the safety valve of society. It's not supposed to be a participant in the political storm, right? So let me tell you how I view elected office. I've been elected now since 2006, in one form or another, and I've been very involved in civics education, and I was with a bunch of students along with some other elected officials. And a student asked the group, when did you feel closest to your position? And the other elected officials went down the line and talked about something they did in their official capacity. When I got to me, I talked about being in the back of the line and shooting for off. And this person I knew came up and spoke to me, called me judge, and they walked away. The person behind me, after they left, said, well, you're a judge, just got up in front of the line. I said, actually, when I don't have my role, I'm like anybody else. And the reason I told the students that is my position is as a citizen first. I play a role as a judge. It's responsibility, not power. I'm a servant, not a master. And that's how our form of government is set up. We have to live up to that, especially, like I said, in the judiciary. Let me tell you a little bit about myself. I was born right here in Toronto, General, in 1958, so I'm old. And I grew up actually mostly in Federway, age 9, all the way for 15 years I lived in Federway. And when I retired, I went to Ellensburg. I retired in 2020. I went to Ellensburg because one of my sons was a police officer over there and 3 of my grandkids were there. And the houses were cheaper too. And then the last 30 days, my retirement lasted 30 days, and here I am back running for the Supreme Court for a reason. You know, we're talking about our founders, their lives devoted to the sacred honor. All I gotta do is put 30,000 miles on my car, meet a bunch of nice people, and get told I'm full of crap. It'd be kind of embarrassing not to try to help us restore the type of freedom that we're designed to have. But disagreement's an opportunity, not a threat. We're entitled to have our opinion. Right now, we're living in a world where I'm entitled to my opinion, you're entitled to my opinion too, right? And we get to get back to where we're more civil to each other. And the justice system should be that guiding post for us, that guiding for us. So I grew up in Federway, graduated from Federway High School, went to my first year at PLU. I graduated from University of Puget Sound in 1980 with a degree in public administration. Took a year off, went to the University of Puget Sound Law School. I very intentionally went to school at night. I worked for the Pierce County Prosecutor's Office in the Misdemeanor Division my first year. I was basically a clerk. My second year I worked in the Civil Division, writing briefs, summary judgment motions, and all kinds of briefs in litigation against the county, anywhere from involving land use to police liability. My third year I went to a private firm called Burgess, Kennedy, Fitzer, and Strongman. I was an intern there. I did all the work a lawyer would do except take depositions and appear in court because I couldn't do that. I could appear in court on agreed motions, but not otherwise. But ultimately, my work there got me a job as staff trial counsel for Safeco Insurance Company. I was there for 3 years, worked for a gentleman named Dick Jensen here in Tacoma for 3 years, had my own firm for 10 years, then went on board with a firm called Williams Castor in Seattle. I was head counsel, it was a 90-lawyer law firm. The type of litigation I did, you needed 25 chairs in the congressman to take a deposition, and I was chair of a department on a national council team managing 15,000 lawsuits nationwide called mass torts, products liability. So I went from that to being a judge in traffic and misdemeanors. So how did I do that? I was president of school board in Federal Way, and if anybody's been around long enough and remembers, has good memory, they'll remember that the Federal Way court was in the newspaper every other day about some controversy. So they asked me to come over and fix it. 18 years later, I retired as the municipal court judge there. And it was one of the most purpose-driven things I've ever done. I wanted to reform the courts in the civil arena before I became a criminal law judge, because basically our time is mostly spent with criminal law and municipal courts. And once I became a municipal court judge, I saw all the things we could do better to help our communities, to help the people we see in court. I've been recognized nationally for my strategies. I was selected by a legislator to represent the state of Washington at a Department of Justice summit in Atlanta a couple years ago on crime. And so in our Supreme Court, I like them all. It's not like it's personal, but the things that are happening in our communities aren't a priority. And we need a Behavioral Health and Justice Commission. We need to make what's happening in our trial courts a priority. As a trial judge, I saw a lot of their decisions are not in touch with what's really happening at the ground level. And I want to be that voice for our trial courts. I just got the District and Municipal Court Judges Association President's Award for the second time a couple weeks ago. And the consensus was talking about I retired and they gave it to me for my career. And I was talking to a number of judges, and the consensus is that the Supreme Court, as nice as they are, they're out of touch with what's going on in our courts. And we need to have a different perspective. A lot of people don't know that the courts, they just don't make decisions, they also create all the court rules, and maybe we'll get into that a little bit. But I ran in 2024, lost by 0.61%. My fifth grandchild was born, and all the stuff that's going on, I thought, what am I going to tell him if he asks Grandpa, what did you do to make things better? So I decided to run, and I'm doing pretty well, and I'm happy I'm doing it. I feel pretty good. So with that, I'm going to turn it over to Judge Stevens.
I understand when you got that award, you got a standing ovation. So, I'm Judge David Stevens, Superior Court Judge of Mason County. In order to understand me, you have to know a little bit about my parents. So my father's family fled Cuba. My father believed in the American dream. He was born in America. His parents were not. He believed that if you worked hard, you followed the rules, you could succeed or fail on your own merit. That was the way I was raised. He did 23 years in the Air Force. And then after he retired from the Air Force, he supervised the maids at the Holiday Inn because his first language wasn't English, it was Spanish. My mother was a career waitress. So when I graduated from high school, I joined the United States Navy. And like Todd over there, I was in the Persian Gulf too. Got some medals for that. So after I got out of the Navy, finished my enlistment, I went to the University of Washington, used my educational benefits. Because that's the great thing about America. America wants you to succeed. America will give you the tools to succeed if you take advantage of those tools. So I took advantage, and I graduated from UW, did very well. So I was hired under the Outstanding Scholar Program, and I went into law enforcement. My job was to investigate complaints of discrimination. My dad felt very strongly that people should be treated the same, regardless of their race, ethnicity, or creed. Because that's America. Equality under the law. So I was in law enforcement for a while. Then I went to the University of Washington School of Law, did well there. When I graduated, I became a prosecutor. They called me No Deal Dave because I felt that criminals should be held accountable. I ended ended up being a federal prosecutor for a while. I was an international prosecutor. Went over to Eastern Europe and tried some cases under their system. Then I also went to Afghanistan, working as a prosecutor, training prosecutors there, training law enforcement there. I have seen places where they don't have the rule of law. And it's terrible because it's all about favoritism. It's all about who you are, who your family is, things of that nature. So a few years ago, Governor Inslee appointed a judge in my county. I was a senior felony prosecutor in Mason County. And she made some decisions that the county didn't agree with, that I specifically didn't agree with. So some people came up to me and said, would you run against her? And I said, running against an incumbent, she's going to have money, she's going to be endorsed by every judge in the state. Because what has happened is the majority of judges, even though the Constitution says they're supposed to be elected, the vast majority of Superior Court judges, Court of Appeals, and even Supreme Court justices are appointed by the governor of the state. And that's had an effect on our courts. So I ran against her, won by 15 points. That's how I became a judge. I was elected, not appointed. So once I became a judge, I became aware of what the court rules were doing. Now, I followed the court rules when I was a prosecutor all those years. But recently they started changing. You know, both my opponents say they're running to protect the rule of law. They both say, and it's in their pamphlet statements, the rule of law has never been under such attack. And it has been. But it's been under attack by the Washington State Supreme Court. And I think we'll get into exactly what they're doing. So I'm running because I don't think people should be treated differently based on their race or their ethnicity. And I think we need to get back to the rule of law in Washington State. We need to get back to the Constitution. We need to apply the laws. Courts shouldn't be making the laws. It's the politicians that make the laws. And I think this is all because of ideological bias in our courts. And that's why I'm running. Thank you.
Thank you, gentlemen. I've got other questions for you. And I guess we'll do this in reverse order this time, so we'll start with Mr. Stevens and Mr. Larson and Mr. Law. You may have touched on this a little bit, but here's my question. Is there a particular concern you have about how this position has been executed, either in general or by an opponent, that has caused or contributed to your decision to seek this office? If so, what is that concern?
Well, originally I was actually going to run for a position that one of my counterparts is running for. They have this Supreme Court Justice, and she believed that the justice system was systemically racist. So what systemic racism is to me is you study law enforcement, and there's always a few bad apples, but you find that the law enforcement really don't care what your race is. They really don't care what your ethnicity is. They investigate the facts, and then they refer cases to the prosecutor's office. So they didn't find systemic racism there. Then they looked at the prosecutor's office, and they didn't find it there either. Always a few bad apples in any large organization. Then they studied the courts. They really studied the courts. Didn't find it there either. But they didn't want the outcomes. So they started changing the rules. And they started saying that when we select a jury, if somebody's biased, if somebody says, I would never trust a law enforcement officer, I think the criminal justice system is corrupt and racist. Well, you'd think that person would be kicked off the jury pool, right? Because they've said they're biased. But they specifically wrote a rule, General Rule 37, saying, no, if you're a minority, a racial minority, or ethnicity, then you can't be kicked off the jury for that. But on the other hand, they specifically said that if you have strong religious convictions, when you were asked about how you felt about being on a jury, but you could follow the law, you could decide the facts, and take the oath, you could still be kicked off the jury. See, they don't really care about your rights. They care about outcomes. That's what the Supreme Court is doing.
That's a great question. It's so multifaceted why I'm running. It's difficult to answer, though, in the sense that I'm not running against any one particular justice. The seat I'm running for, Justice Madsen, is retiring, so it's not like I'm running against an incumbent. I made the decision to run before Governor Ferguson appointed the person that is now in the position. His name's Theo Angeles. That appointment further bolstered my desire to run because Governor Ferguson appointed the first appointment, Justice Melody, was somebody who worked directly for him at the AG's office, which by itself is okay, what the heck. But the guy that I'm running against now, because he got appointed after I decided to run, has been a campaign contributor to Governor Ferguson since 2009. Has already given money to Governor Ferguson for 2028 gubernatorial campaign. He's also given money to key players in the income tax litigation. And so there's a direct attack on judicial independence. I was given the 2018 President's Award from my Judges Association because of my fight for judicial independence across the state. So it's a direct assault on judicial independence. The reason that's so important is the third branch of government is supposed to be a backstop, not an open gate. You don't appoint your friends and people that are going to be friendly to your decisions in the executive and legislative branch so you can get your way. That's not what's supposed to happen. The judiciary is supposed to be, again, be that backstop, be that something that stops abuse. And if people are in play in those positions that even appear to have those kind of relationships, it creates competence issues for the judiciary. But my primary reason for running has to do with how the courts are administered. And especially in the area of criminal justice, in the sense that we're having problems in our community. Supreme Court has made it worse with Blake decision, basically legalizing drugs for 2 years, made our communities worse. Public defense standards, when they lowered those, the numbers of cases, without having a solution, they've created problems in our communities and for our local jurisdictions, without really solving anything. The most recent, the straw that broke the camel's back this year, was a rule that will make it almost impossible to issue a warrant if somebody doesn't show up in court, which will further degrade the criminal justice system, on top of some of the political ideology that's fueling those decisions. And ultimately, we've been talking forever in our court system about making the system less expensive, less complicated, et cetera, but nothing changes. When it comes back to criminal justice, it's like Rome's burning and they're fiddling. And again, I don't have to dislike them to disagree with their approach. When it comes to race, the things that they're doing, writing letters and citing cases, citing a letter in cases and everything, isn't helping people in our communities. What I've done in my court, my motto is I run a repair shop, not a junkyard. I show people what success looks like, not scare them to failure. That works. So in 2020, in the height of the George Floyd issues that we were affected by in this country, and I was running against a minority candidate, the Lauren Miller Bar Association, because of my work in courts, gave me an exceptionally well-qualified rating, and they're the bar association that represents black lawyers. And they gave that to me again in 2024. It's because things work in the courts, and they ignore it. And as Judge Stevens said, because there's only 2 trial judges left on that court, they don't have a feel for what we need in our trial courts to make us have effective justice. So the types of things you're seeing with people cycling through, I was asked questions earlier about people that continue to be released, because in some cases it's given us the green light in our courts to take sides, and so equity becomes an issue when you're letting somebody go, but under the rules you wouldn't let go because of their circumstances. And ultimately, it sounds unsympathetic, but it's the opposite. Basically, people want structure. People I see in court, when you approach them from the standpoint, I want you to be my neighbor eventually at some point, and you approach them early, and the first time they're in court, you actually have a strategy. It improves life, it makes people's lives better. But the system now, we don't have a strategy, we don't have leadership, and we're just kind of going around and stuff, passing people back and forth, and the Supreme Court's been silent. So that's a long answer to your short question, but I get paid by the word. But anyway, but there's so many other things that go into it. But really, Article 1, Section 1 of the state constitution says, all political power is inherent in the people. Governments derive their just powers from the consent of government, and the purpose of government is to protect and maintain individual rights. I operate by 2 rules. Love the freedom of others as much more as you love your own. Is Rule 1. Rule 2, it's more important to do right than it is to be right. And what happens in our courts is, again, like I said earlier, it's all about power and control. It's all about being right. And what we have to do is recognize that the people we serve are the people that live in our communities that are trying to live their lives without crime affecting them. People that come to court that are accused of crimes or have a civil wrong that they're trying to solve. Those are the people we have a duty to. And I end with the idea that dignity and respect is as essential to us as eating, breathing, and sleeping. And we don't deliver that in the system. And that has to be our primary focus. And so to the extent I can change that model, kind of mode of operation of the courts, I'm going to do it. And I've been at it for a while. I've made some progress, but I'm not done. Thanks.
All right, I was counting on Dave to quote the all political power is inherent in people section of the Constitution. And it's wonderful. And I also want to kind of pick up a couple other words that are very important to me that I've heard referenced here, and that's responsibility, accountability. And unfortunately, I think what we're seeing is that people want to be responsible, they want to hold their leadership accountable. But unfortunately, picking a judicial candidate is really hard for a lot of voters. And so there's a chronic problem of undervotes for judicial candidates. And so everybody knows who they want to vote for governor or for senate or for president. But they get down to the page where it's got lawyer A and lawyer B. How do they know who to pick, right? What's the right thing? And so when it came time for filing, and like Judge Larson, I know, working in the state board of governors of the state bar, I know all of the justices personally. I deal with them in a professional capacity in that regard. And they're all fine people, they're very nice, whatever. But that's not what we need right now. And voters need to hold our elected officials accountable, and that includes sitting justices who are running for re-election on the state court. If we think, oh, well, I really like Judge Larson, the rest of these folks, whatever, it's 1 out of 9. There are 5 judge positions on the ballot out of 9 this year. This is a historic anomaly. It's an opportunity for the state to say, hey, we didn't get this wrong. We need to hold these people accountable. And as much as good a good person or whatever they may be, is whatever is social interactions or whatnot, they're not doing what we need as a state. And I think that one of the things, and I think Judge Stevens has also referenced it, is our leadership and what we model. And so I think the leadership that the type of leadership that we bring is different in quality than the kind of leadership that kind of just everything's cool, but let it run, whatever. We've got these whatever these problems are, you shrug, the old Ensign salute, as you would say, right? Whatever. We can't take that attitude anymore. And in fact, I've been encouraged. I ran a couple of years ago, as I referenced. I've been encouraged, and when I was looking at filing, essentially it came down to challenging the Chief Justice who's on the ballot this year. And on Friday morning, when I was getting ready to file, I was like, no, well, she needs a challenger. Turns out she's got 3 challengers. So we'll kind of see what happens. But that was really one of my concerns, is that, hey, if we just, Judge Larson and Judge Gibbs might reference specific blank. We look at the clearing. What's happening with the clearing? Educational spending is just, we've had a tsunami of spending. So we've had some really good outcomes for education, right? My recollection is that this continued to slide. And one of the things that, if you look at the code of judicial conduct, I think it's in Canon 2, it talks about independence of judiciary. And independence is incredibly important. And one of the things it says is that you shouldn't be swayed by the opinions of your associates and those things, and you shouldn't be swayed by public clamor. Well, what if the public is clamoring for the court to uphold the Constitution? What if they're clamoring for common sense application of the law and fidelity to the Constitution? It's almost as if they take it as a badge of honor that they've ignored, done the opposite of what the public clamor is. And the results show it seems like. We see the municipal election in Los Angeles. Oh, well, when we solve our problems around this, Senate should follow up to Seattle. They know about it, right? Societal problems. We're not here to set policy. We're not here to be policy. Judge Larson sees expression. We're a backstop, not a back door. These different kinds of things, right? An open gate. So we need to take that seriously. And I think that that's one of the reasons, these lovely people, it's not going to be the same without her, but hopefully we'll be able to experience that over the next few years and have some, and if I need to be held accountable 6 years from now, by all means, vote me out. But I think that, that's one of the issues with voters is, there's that advantage of incumbency, and sometimes there's a reason for it, and sometimes it's just a default position. I think this year is going to require a lot more scrutiny and as to what those, what the candidates stand for and how they're going to operate when they're on the bench. So, with that, do you have a discussion?
I've got a whole bunch of questions here in addition to my own, which are minor design to try to ferret out the general sort of way. At least a little more specific. Try to get as many of those as we can. So this question is, and maybe the next one also fairly short, I think, to answer. What do you regard as your most significant professional experience or training as it relates to the Washington Supreme Court? And I guess we'll start with Mr. Larson first, this one. And then we'll move to
I think it's 18 years as a trial judge. The NFL doesn't use former players to do instant replay. And there's reason being a judge. It's like describing when you're a trial lawyer for 23 years, like I was. You kind of have an idea what it's like to be a judge. It's like describing what it's like to be a parent of somebody who's not kids. Until it happens, you really don't really understand the significance. And I think having that perspective, having to make the calls, because the Supreme Court sits in judgments on the mistakes made by trial courts. And sitting in that position, I have 3 times the experience of the closest person to me, and the 2 other people have no judicial experience. That's probably the most, for me, the most significant aspect of my career that all needs a tool on the Supreme Court. And
So I think, a couple highlights that probably address that. I think the breadth of experience and experience in other fields out that are not, that maybe related to the law but are not directly legal. I think and I think the military experience. My interaction on a routine basis over the last 20, 30 years of my career or whatever, it's been a lot different, I think, than most lawyers probably. Certainly, I would say many, if not most, judges as well. And I think the quality of the type of experience, 20 years of mission service as a military officer, and the kind of trust that's inherent in the professions I think that I bring is probably higher than
So I've been a prosecutor most of my career, and I agree with Todd. Military experience was formative in my life. I did that when I was very young, and it gave me a clear idea of how we should treat people. People should be treated with respect, they should give respect, they should follow the rules. But being a prosecutor, and I was a public defender also, I did some appeals that went up and had significant effects on the law. I saw that things were wrong. There was something wrong with the statute, and I took it up, and then I went and I got things changed. That's the way it's supposed to work. You have the trial courts, Judge Larson, who was in municipal court. Actually, the lower courts are more important in a lot of respects. I'm superior court. By the time you hit my court, if it's a criminal case, you probably have a history. And if you had a good judge in one of the lower courts, municipal court, something like that, and they could catch the case early, they could really have an effect on somebody's life. So I would say that my experience as a prosecutor, a public defender, and as a judge, having actually been in the trenches, you have these people that have these ideas, these concepts. They think things are new. They knew when they drew up the Constitution, both the state and the federal, they understood people. And that's why those constitutions work so well, because they had checks and balances built into the system. But now we don't have the checks and balances. We have the courts, the Supreme Court, that they believe that they are the supreme branch of government, and they can dictate to all the other branches. And that's not the way it's supposed to work. I really liked what Judge Larson, when he described what the Supreme Court was doing. So you're going to hear a lot, and you've probably seen it in the newspapers, where they say the courts are the co-equal branch of government. That was never the intent. Never the intent. They're not supposed to be a co-equal branch of government because they don't do policy. All they do is make sure that the laws follow the Constitution and rights are protected. They're the backstop, as Judge Larson says. And I think we've gotten away from that, and now they're indulging in policy the way they want to see the world work, and that's not their job.
Okay, that was about professional experience and training. Third question, again, kind of short one. Describe your most significant personal characteristics or traits as they relate to the Washington Supreme Court. And I guess we'll start with Mr. Stevens and Mr. Larson.
I think the thing that people find most interesting about me, if they get to know me well, is I used to compete in powerlifting. So, in order to lift really super heavy weights, you need a lot of dedication. And you got to stick to it. You got to do it years and years. And actually lifting weights is more about failure than success. So I was taught by my father that when you're not good at something, if you stick to it, maybe you won't be the greatest, but maybe you can achieve competence. And that's why I was able to get a lot of awards when I do my powerlifting. And yeah, I got hit by a impaired driver about 4 years ago. It destroyed my body, so I can no longer do that. But I competed for about 20 years. So you want to know that somebody is able to learn, that they're able to stick to something, and that they can accomplish things if they stick to it. And I think that's the important characteristic that you should know about me.
Well, speaking of competition, I think I'm the only judge in the world that's eligible to drive a dragster in any charity competition. So I used to do that all over the West Coast. But I joke that I'm pretty proud of my humility, you know. But to be in elected office, your humility also always has to be one step ahead of your time and your responsibility, because that's really what it comes down to. Is if it's not, you can't. That second rule of it's more important to do right than it is to be right is fueled by that humility. Always knowing that you don't have the answers. In fact, I told the lawyers at court, the minute I forget what it's like to be a lawyer, I'm going to resign. The minute I think I have all the answers, I'll resign. Now, if I make the Supreme Court, the minute I forget it's like, added to that would be the minute I forget what it's like to be a trial judge, I'll have to resign. Because those things always have to temper everything you do. And I think any government official, not just Supreme Court justices, humility, especially in this day and age, has to be our number one strength and our number one trait, because we need a lot more of it. We're in the position we are now because we fooled ourselves into thinking this whole thing's about power control. And when it's about power control, it's all about ego and the opposite of humility, pride.
I think what they both said, I don't want to just piggyback that. No, I think what I would say is my professional skepticism. And lawyers are trained in law school to be skeptics. In accounting school, to be an auditor, they teach you to be a skeptic. And to question the numbers, question the reality, question everything, right? So I think that, and that also kind of ties into independence, forming your own judgment, maybe listening to both sides intently, and then figure out what the actual facts are. Now, it's going to be different. I did serve as an arbitrator and decided cases from financial controversies, and have decided cases as a FINRA arbitrator. It's not quite the same as Judge Larson. It's not quite, like Judge Stevens, their approach and their impact, perhaps. But nevertheless, you're making decisions. You've got to have that independence, the integrity, and fairness to be able to give all sides a proper hearing. Hear them out, hear everything. Don't cut them off when they get to 2/3 of the way through it. If it's redundant, maybe there's some additional something to be learned. But I think those professional qualities, skepticism, and keeping an open mind. But if you look at my resume, I've got a lot of degrees, a lot of professional certifications and stuff. It's easy to get a big head. It's easy to do that, and to lose sight. Hey, I'm the expert, whatever. What do you know? And so I think having that humility to think, hey, I can learn something new. I can find, I can change my mind. I can form a new opinion on something if I just keep an open mind and have that humility to be a lifetime learner and to constantly be open to new things. So I think those personal characteristics.
And this is kind of the last question, it's for personal qualities. And we'll start with Mr. Blum and Kevin first. Please describe one or two accomplishments or contributions of which you are most proud.
Well, I just had my 40th wedding anniversary. I have had such an honor and privilege of being married to my sweetheart from college and making it work for that long, as God knows, product and servant. And so that's incredible experience. And I credit my wife with it's biblical, iron sharpened iron, and having her as a spouse and a supporter and somebody who's always there for me. If I don't know it or recognize it or appreciate it. But I do have a lot of other professional accomplishments and things I've done, contributions to different organizations, and I think one of the things I would say is probably my willingness and my effort and dedication to going beyond over just putting in 9 to 5. It's whether it's for my church parish finance council or being a Eucharistic minister or something of that nature, or creating a chartered financial analyst exam, or serving on the state bar. one of our counterparts referenced the public defender rules that just came down. And that was an intense debate at the state bar level. And I questioned the wisdom of what was going on, and I was kind of roundly penalty for it. But I was the one vote against the recommendation to the Supreme Court. And I certainly think it's worth revisiting and recalibrating, because I think that does insert some concerns. And but I think I think familial relationships are very important. They're our first educators as children, our parents, and that's really important to the profession. I think it's probably the volunteer work that I've done in the organizations that I've been involved with from that perspective.
You can go on my website at larsonforjustice.com and get the full picture, but the first thing that came to mind was my two sons. One's a deputy sheriff in King County and just transferred from being an Ellensburg police officer. The other one's an internal medicine physician up in Mount Bryan. Then my 5 grandkids, so they're my best friends and my pride. The other thing's probably the fact that I overcome resistance with the changes I'd like to see in the criminal justice system, to a point where those things have been adopted in a lot of cases, and to getting a standing ovation at the most recent judicial conference because of it, and the fight that I had to. But it's not over. I'm only about 40% there, but I think it's the fact that I don't give up, and I think that is what I'm running for the right reasons, and I think we're going to look back and I'm going to feel good about the fact that I did not give up.
I often say I did really well as an undergraduate at the University of Washington. But the most important thing I did there was I met my wife, and we're working on 31 years of marriage. But it took 5 years to convince her to marry me, so I think I should get some credit for time again. But what am I most proud of? Some of the cases I've done. There was this guy, Otto. So Otto had a lot of convictions involving drugs. And so I got this case on Otto, but he'd never gone to trial. He always got deals. But he'd done too many cases, and so I took him to trial. And it was a tough case to win. Everybody kept telling me there was no way I could win this case. And so Otto got convicted, and I made sure that Otto went to drug treatment. So about a year, 2 years later, I'm in line to go into court as a prosecutor, and I see Otto in line. And it just really ticked me off. And I did this, it was probably unprofessional at the time because he could have been prosecuted or something like that. I turned around and I said, Otto, what are you doing here in court? And Otto said, I'm here to get a marriage license. So Otto said the best thing that ever happened to him, because he'd been ordered into drug treatment all those other times, but there was never any follow-up to make sure that he did it. And he said he had kicked the drugs, and he turned his life around because he had finally been held to account.
Good.
Those are the kind of things that if the justice system is working correctly, we can change people's lives. That's why I say it's so important, the work that Judge Larson did in the lower courts, because you can actually change it. Another case, I used to do a lot of tribal law, and I was working for a tribe, and they had a sentencing provision, and this will shock you, the Bill of Rights, the 4th Amendment, 5th Amendment, things we take, we all believe apply to everyone. They don't apply in tribal courts. So in tribal courts, it's the Indian Civil Rights Act of 1968. And so they were sentencing people to sentences that weren't allowed under the law. So I challenged this. It took me 3 years to get through the appellate system. And finally, I got to argue it at the highest court. And I validated their entire system. That ticked off a lot of the prosecutors. But then they started doing it right. And you know, like Dave says, you gotta do right. See, being right is not the most important thing. The problem with our courts now is they believe that they are smarter than society that has existed for thousands of years. That they now have new insights into how to order society. And they don't want to learn from the wisdom of the past. So they think they can change it. And that's not the way it works. So I would say some of the cases I've done where I've changed lives are some of the things that I'm most proud of. And of course my wife, Matt, she put up with me for 36 years now.
Gentlemen, what do you regard as the proper role of the Washington Supreme Court Justice in our government? And in what way do you regard the present court as having succeeded or failed in carrying out that role? Let's start with Mr. Stevens and Mr. Larson.
So the way it's supposed to work is the legislature passes a law. So they tell you, they give the court's authorities to do warrants. And then the Supreme Court, the rulemaking authority, would do a rule. And then actually you look at the case of it, they say it's mechanistic. It's mechanistic. The legislature passes the law that applies to the courts. And then the courts implement that by a rule. So that's the way it's supposed to work. But that's not the way it's working. So take juvenile cases. I did juvenile cases. Some of those are heartbreaking. I can't tell you how many times I have 14, 15, 16-year-old girls. These older guys would get hooked on drugs. Hooked on drugs. Some of them would be turned to prostitution. And then they'd start committing crimes. And they'd come into my court, and I would order them to do drug treatment. We were able to hold them accountable. We were able to help a lot of these girls. But there was a law that said we could issue a warrant when they violated their probation, when they didn't do what they were supposed to do. So the Supreme Court instituted a new rule, the Juvenile Criminal Rule 7.16. And they said, in a case, that just because a girl was suicidal, because she wasn't following her probation, you couldn't issue a warrant. In fact, they put in the rule that all the warrants that were outstanding for these kids who needed help had to be voided. And it went up before them, and they got to decide whether they could nullify the state legislature's law. And they said, oh no, these things can be harmonized. Even though the law says otherwise, we're just putting additional requirements. So now these kids, when they violate the probation, unless we make a specific finding that they're a danger to the community. You know, committing thefts, you're not a danger to the community. Not doing your drug treatment, you're not a danger to the community under their rule. So then you can't issue a warrant. Those are the kind of things that they're doing. And they need to be stopped. Somebody needs to be there. So like Todd said, this public offender caseload thing is insane. We had a hard enough time finding prosecutors and public defenders. We couldn't hire enough. So what they do is they institute a rule saying that for felonies, you can only do 147 cases if you're a public defender. I've been a public defender. You can do it. It's hard work. It's very tough. Very difficult. But then they weren't getting the outcomes that they wanted. And they cited things like equity, and equality. And I always, when people say equity and equality, I always wonder, what's the difference? And they won't tell you the difference. They won't tell you the difference between equity, and equality, because they don't want equality. They want equality of outcomes. And then they lowered it to 47. So in my county, we budgeted for 3 public defenders, and we've been able to do that for a lot of years. Those people worked very hard, and they were doing God's work representing people. But now we have to have 9. So a bigger building, more IT services, benefits, it's going to bankrupt small counties and we don't have the attorneys to fill these jobs. They don't exist at all by that number in the state. We took all the graduates from law schools that are coming out in the next couple of years. It still wouldn't even come close. And you know what? When they were asked, when Judge Deborah Stevens, who he's running against, was asked, well, this is going to destroy counties, it's going to destroy the system. She said, that's just not our business. Because that's what they care about, outcomes. They don't care about justice, in my opinion.
So on that note, when it comes to public defense standards, I've read the paper actually how to actually fix it. And it's not just about how many cases are handled, but that's a different issue. I brought up the football analogies twice now, this is the third. So if you can imagine the legislature being one team and the governor being another team, the court's supposed to make sure everybody stays in bounds and follows the rules, right? They don't hike the football to one team. They don't get involved in, making sure the team scores a touchdown. They don't do that. They're basically the independent, objective referee, right? And I'll give you an example to illustrate why I think the personal agenda part, and when you're electing judges, it's not what our personal opinions are, it's our ability to overcome our personal opinions inside the case based on law and the Constitution. And the Blake case is an example. One of the justices in the dissent called out the majority because they came up with arguments, the majority came up with arguments that the lawyers didn't even come up with to declare the drug laws in our state unconstitutional. That's basically taking the ball or passing the ball instead of just listening to the arguments and making a decision. Now the reason that's by itself is like, okay, what the heck? That statute had been upheld twice before by our Supreme Court. And the U.S. Supreme Court said the type of statute we had, which is strict liability, which means you don't have to show knowledge that you had drugs on you, that's constitutional, right? Personally, this is an example of what you go in, what a judge is supposed to do. Personally, I think it's unfair to have a strict liability statute when it comes to drug possession. But my role as a judge is not to second guess the legislature or second guess precedent. It's to apply the law the way it's written. And in my comments in the case, I can say, hey, this is unfair, legislature, please rethink this. But my place as a judge, or not just me, anybody, place as a judge is when the case of the statute is otherwise constitutional, otherwise enforceable, decide that you're going to interpose arguments that lawyers didn't even make to declare it unconstitutional. And that's an example of what I think the court's doing that needs to change.
Good.
So I think our judges on the panel have exposed kind of the structural component of what the courts overall should be fairly well. I agree with what they've said, how they've said it. I think for the most part. I think the other thing too is it's a statute, it's a constitutional branch of government. Whether or not it's co-equal and what co-equal would actually mean, it's clearly not a policy prerogative, being a judge or a justice. Should not be, should I say. And I think that our court though shows deference when it shouldn't, and it shows initiative when it shouldn't. And I think like for example, the Cleary case. This case was initially decided, I believe, in 2050, but then they went through several iterations before they finally said it's okay. And I view this, and different people can have different views, but in my view, that was an overstepping of bounds to legislate from the bench. And I think the other thing that I look at is, does the court properly hold the executive within the executive bounds, the governor, the attorney general, the state agencies? And so I think that in a number of cases we've seen excess deference to the executive the executive appointed you, well, gee, that's a real mystery why that would be, right? So I think deference to the executive in overstepping bounds would be a couple of examples, I think, of things that certainly I would be cognizant of as a justice, because I think it's been, the Supreme Court has got it wrong, and has for several years.
Okay, this has been touched on just a little bit, but let's make it more expressive. What, if any, do you see as the prudential limitations on Supreme Court rulemaking? And I think we started with Justice.
And by the way, my football analogy I used earlier, it could be involved litigation with one defense and plaintiffs on either side of the ball, too. So the court has some broad rules. In the Constitution, the court is provided the power to make court rules of practice and procedure. By state law, they're given the authority to create rules by rules of practice and procedure. There's a statute, RCW 2.04.100, that says if the court has a rule that's procedural in nature, that the court is operating the courts, if the legislature passes a law that's different than that procedural rule, the rule controls over what the legislature passed. That's how much power the court has. The court doesn't have power to interfere with substantive rights. It can't create a rule that redefines statutory rights or redefines constitutional rights or anything else. But in terms of the way the court operates, the court has broad power to create rules. And that's consistent with separation of powers and checks and balances. The idea that it's an independent branch that decides how it's going to run, because the legislative branch, or the executive branch for that matter, could kind of impose their will on the courts if they got to tell the courts how to run. The outcomes could be affected by how the courts are supposed to run. So that's why you want that independence. It's what the court does with that rulemaking authority that becomes the bugaboo. It becomes the thing that affects communities, because the rules are anything from how courts operate. We have administrative rules. We have rules that on the admission to practice law. We have rules that the court, and then that's kind of this mixed bag of statute and court rules. But we have a number of rules that affect what evidence juries hear. We have rules that dictate how cases are processed, both civil and criminal. And so there's a huge role, and as Todd mentioned, the Bar Association, a number of players are involved. And it's a pretty significant part of what the court does. It's one of the most overlooked things that the court does. And the thing I bring is from running court for 16 years. I ran a court for 16 years. I was presiding judge for 16 years at my court. There's only 2 judges. And all the other things I've done, that rulemaking authority is probably where I think it had some strength in the court. That wasn't it.
So the question had to do with prudential.
What, if any, do you see as the prudential limitations on Supreme Court rulemaking, as opposed to the legal limitations?
Right. And that's fine. And I think, but I think it's important. Judge Larson can certainly give us the context and kind of thoughts on appropriate rulemaking. And I think that I would, I don't think I disagree with anything he said, certainly. Sometimes, I remember when I was growing up, maybe y'all may be familiar with the old expression, I don't remember if it was a TV show or something back in the day, but used to people exclaim, "They're off the law." And that was, something frustrates you, something upsets you, whatever, and they ought to outlaw this or outlaw that. No, we've got so many laws in America, at the federal level, the administrative, the regulations, the state, all the different agencies, all that stuff. I think we need to repeal about 2/3 of our laws, or uniform, make a way to harmonize the laws. so, because, it's like the observation's been made that you can hardly, get up and make your breakfast without violating, 10 laws or something like that, whatever, right? It's just, you can't go about your business without having the risk of that. And I think that sometimes that kind of overbearing thought that, man, I'm guilty no matter what I do, I can't even turn around without breaking some law probably, right? Spitting on the sidewalk or whatever it is, right? And some societies, in Singapore, that'll get you some lashings if that kind of thing occurs, right? So in that sense, I think from a prudential aspect, and think about it in those terms, we should probably be more concerned about streamlining rules and regulations and making sure that they're sensible. We don't just leave them on the books if we make some new ones or whatever we do to make them effective and beneficial for society. I think that so often that just is oversight, or that because it gets proposed in the first place, there must have been some kernel of truth, there must have been some example or something, some incident or situation that gave rise to the belief that there ought to be this rule in the first place. Well, maybe revisit that and determine, is this a problem, or is this a solution in search of a problem? Because a lot of times you'll have people, approaching it from that perspective. They've got this great idea, and whether or not it's really legitimate or whether it's a real concern, a lot of times it's a secondary consideration. So I think, from a prudential perspective, I think that, people feeling overburdened by the law. And the other thing I think, which hasn't really gotten raised or got much discussion about, is not enforcing law. The failure of law enforcement is one of the most things that's corrosive to the law.
Yep.
And I give an example. I hear it, I see it, I hear people talk about it. They'll be sitting at the grocery self-checkout, and you've got, one more item than the thing suggests that you're supposed to have. And the clerk comes over and chastises you for having one too many items. In the meantime, you look up, and there's somebody pushing $500 worth of groceries in your cart right out the front door. It's no big deal. Now, this is a relatively recent occurrence, right, since COVID. But the thought that laws are not being equally applied is corrosive. So we've got the state bar, and I applaud our effort. We're promoting the rule of law in society, and it's important to get in front of particularly young people who may not have formative, the examples and the discipline in the home that teaches about the respect for law, the respect for other people, and keeping your hands to yourself and not from your siblings or whatever. Things like that you learn that, as a society, it seems like we're forgetting these things, and these are not needed. But the lack of enforcement, I think, undermines and corrodes the rule of law, one of the most corrosive things. So I think we need to make the law understandable to ordinary people. We need to make it so that it's not, doesn't allow for these kind of double standards, because that's a real problem. Now, I kind of got off track a little bit because, those things don't really relate as well to the question, but I think we ought to have that kind of mindset when we're looking at rules and what the effective rules are.
Mm-hmm. Yep.
So given the question, it's about separation of powers, it's staying in your own lane. So Judge Larson talked about this a bit in the new bill. So our Washington State Constitution says that everybody has the right to bail, reasonable bail, except if it's a Class A felony. So murder in the first degree, rape in the first degree, forcible rape, child molestation, child rape in the first degree. So you don't have a right to bail in those situations according to our state constitution. And the legislature passed laws, they're in Chapter 10. And it says that if a judge says, because you've been charged with that, and they found a history that you're dangerous, you can be held without bail. And then they give a procedure where the defendant can immediately appeal this one issue to the Court of Appeals. So the legislature, the Constitution, and then the court rule. The court rule says additionally. that you can be held without bail in these infamous crimes. So what's before the state Supreme Court, which they decided they would consider, they would remove that ability, even though it's in the state constitution, even though it's in the statutes. They don't want people being held. Even though they've been charged with murder in the first degree or forcible rape, they want those people to have bail, and it's got to be reasonable bail that they can make. That's what they want. And it's because of ideology. They're not staying in their lane. They're not adhering to the separation of powers. See, staying in your own lane, knowing what you're supposed to be doing, that's being prudent. It's not acting on ideology. That's how I answer that question.
This has kind of been touched on, but I'm going to make it more express again. Some people are concerned that Supreme Court justices disregard legal precedent or express language in the state or federal constitution, decides cases based upon their own political and policy preferences when these conflict. How can the Supreme Court collectively, or you as a member of the court, assure people that that is not the case, and how can you, or you win the confidence of the people?
So, Plessy v. Ferguson, that was decided, and it was after the Civil War, and they said that you could treat people differently based on their race. There's a famous dissent in that case. Everyone should read it because it's really uplifting. So sometimes precedent can be wrong. And it took until Brown versus the Board of Education when they decided, no, people have to be treated equally, treating them differently, segregating schools, things of that nature. So sometimes precedent can be wrong. But generally, precedent is what you read. So when somebody comes and I've got to decide a motion in my court, they cite the statute, they cite the rule, and then I go read the cases that have interpreted that rule. And I read the cases that they cite, because sometimes they can be a little shifty in how they cite the cases. And then I apply the law, so we follow precedent, but sometimes precedent can be clearly wrong. Look it up recently with gun rights. For years and years, states were regulating gun rights and saying basically you didn't have gun rights. And then it took the U.S. Supreme Court a long time before they decided the Heller decision. But 2 weeks ago, our Washington State Supreme Court decided that if you have 2 DUIs, that you could lose your gun rights. Those are strict liability crimes. You're over the limit and you're driving. No intent element whatsoever. And then a week later, Vermonti decision comes down about people that have smoked marijuana. And they said, no, you can't take away somebody's gun rights. And then we saw just this week when their Hawaii decision came down. So our state Supreme Court, because I don't think they like gun rights. I don't think they want people to have guns. And they decided this decision. I think it's in direct conflict of those two cases that just came down. And it's clear if you read the decision, it's based on ideology. So I think we have a real problem.
The way the question was worded, I wish I could say that wasn't the case right now, but it is. I brought up the Blake case, and so how does that change? Even one voice that's contrary on the court that says, wait a minute, we can't do that, will make a difference. Because if you're in a room and people are all like-minded and they have the same kind of agenda and everything, and they feel good about themselves because, they can be acting in good faith, they just, but ultimately, there's nobody there to say, wait a minute. The story I tell about that is my priest asked me to mediate this marriage that these two people, 46 years together, they were going to split up, asked me to help keep their marriage together, and I was a mediator at the time. And I said, well, I don't do family law, and I'm not a marriage counselor. He said, well, do it anyway. I wanted to say nice things at my funeral, so I said, okay.
But one guy was a Boeing engineer, got us to the moon, helped get us to the moon, and he wanted to be real risky in retirement, invest in a lot of these inventions and everything, and the wife wanted to settle down, be conservative with the money, maybe pass on some money to the kids. And one of the sessions, private sessions with this guy, to justify himself, he said, if it wasn't for people like me, we would have never made it to the moon. And I looked him square in the eye and I said, if it wasn't for people like your wife, we'd have never made it back. The point is you have to, disagreement's an opportunity, not a threat. We've come into this belief that disagreement's unseemly. And you need people on that court that are going to say, wait a minute, that's not consistent with our principles. The other thing is we have to have somebody reminding them that it's about principles, not partisanship. You know, that has to be the mode of operation. You have to have somebody that says, no, we're lighthouse in the storm, not the ship lost and sea. We're a backstop, not an open gate. Because if you think you're there, and Chief Justice, when he was Chief Justice, Justice Gonzalez, flat out said, we're here for social justice. And first we have to perfect regular justice and put social justice. The point is I don't disagree with a lot of the outcomes they want to see. The point is that how do we deliver those outcomes in ways that are effective rather than just and patting ourselves on the back and doing platitudes. We actually have something that's effective that works, and that's what we need. So ultimately, that's in terms of the confidence level. I think confidence comes from what you do, not what you say. And so getting the court in that direction, getting the court to get more back in its lane was needed. And keep in mind, Federal Way Municipal Court, when I went on board, made national news. I won't get into all the details. And the first year I took over, or first year after I took over, I brought all this. The day I took over, I brought all the staff together because it was really, morale was low and everything. I put 3 rules on a plaque. I put it on the wall. It says, do what's right, do the best you can, treat other people as you want to be treated. The year anniversary I put, there may not be an I in team, but there's always a you and us. But that applies globally across all of us as citizens too. So that's what I want to be able to do, is restore confidence in our courts. I love what I do. I almost quit the practice of law back in 1998 when I was drag racing. I was going to open 3 Valve League oil franchises and finance my habit. But it's one of the more noble things we can do in our life is to be a lawyer, help people with their lives, and to be judges, help people with their lives. So that's what I'd like our system to be, and that's why I'm not giving up on running.
Nice.
What was the call of the question? So inspired.
Some people are concerned that the Supreme Court justices disregard legal precedent or express language in the state or federal constitution and decide cases based upon their own political or policy preferences when these conflict. How can the Supreme Court collectively, or you as a member of the court, assure people that that is not the case, and how can it or you win the confidence of the people?
Yeah, that's an involved question. and it's a good one though. I think that what you do, your reputation, your actions, it's been said, your actions speak louder than words. And the way you conduct yourself, are going to give people confidence that you're able to operate at the level doing what it is you're supposed to do. And that's part of the benefit of having the messaging, the forums, the opportunity to articulate these to voters so that they can have confidence that you're going to operate in the appropriate way, which of course is to replace the Constitution as the frame of reference, whether it's a law, regulation, action by the governor, an action by an agency, for example, or whatever. And I think some of the examples that Judge Larson and Judge Stevens referenced are good. But I think from my perspective, I've been that person on the board of governors of the state bar. I don't think it's any secret that it's a rather left-leaning organization. organization. And I'm more centrist, center-right, probably, personality, my demeanor and experience and background. And that's okay. I've got, to the same extent, I've got personal relationships with the state justices, my relationships with my counterparts on the board of governors. We don't always see eye to eye. And sometimes it's difficult, particularly when you know somebody personally and have a personal relationship, to say, well, I don't, my perspective is a little different. My perspective is informed by this, and this, and this, for example. And then have that conversation and push back and argue about why those things. Arguments should not be the straw that broke the camel's back that now you're out of my life or whatever, right? Particularly if you're in an organization where you've got to come back that next day and you're talking, you got to talk to the same folks, you got to make some further progress on this decision. It's a difficult thing. And some of you experience it sometimes, and I'm sure everybody's experienced it, whether it's a boss, a parent, an employee, a colleague, or something, right? You may have some disagreement or difference, and it might not get resolved right away. In a case, it may form the form of a dissenting opinion. You're not able to swing the other justices' decision or bias on the subject. But it's having the integrity and the determination and discipline to make that known, because sometimes the law is very slow in changing. Between Plessy v. Ferguson and Brown versus Board of Education was decades, and sometimes it takes decades for bad law to be resolved. And so I think that my experience, having been the odd man out, having been that one who has to make that, to raise an objection and discuss it calmly and firmly, and letting people know this is my opinion, this is my vote on the subject, and if you want to join me, I think there's good reasons for it. But that's where I'm at. So it's a very difficult thing, and some people fold and say, oh, okay, I'll join the consensus. And it's knowing, when it's appropriate and when it's not, and having the personal integrity and discipline to do that.
I'm going to skip my next questions because where you just ended up is maybe a good place for this question from our audience. What legitimizes breaking with the principle of stare decisis? Of course, for those who are not Latin scholars, stare decisis has to do with the principle that a legal decision once made carries weight going forward with other cases, and if there's a conflict, the prior existing precedent. You want to go forward with practice? Sometimes
That's a challenging question. Stare decisis as a legal principle is one of the first things you learn in law school. But it clearly, we've seen decisions, we've seen changes in overturning of previous precedent at the U.S. Supreme Court level, at the state Supreme Court level, at the appellate level, all over the country. Now, the way it works is that typically, the cases that reach the U.S. Supreme Court, there has to be a split among the circuits, i.e. differences in the way the law is applied in different geographic jurisdictions around the country, which then bring that previous decision into question, and whether the rationale is circumstances have changed or something that informs the decision, the later decision. But it's not to be undertaken lightly, I would say. Now, but it should be ruled out in appropriate circumstances. I mean, if we look at any number of cases over the last decade or so, probably, we essentially fine-tune what the law is, whether it's an extension of the current law, a reversal, or how the application is under a different set of circumstances. So I think it should not be undertaken lightly, but I certainly think it should not be taken off the table.
So I used the lighthouse in the storm analogy earlier. Well, precedent represents a brick, the bricks that make up the lighthouse, right? And the question is, are the bricks made out of cement or are they made out of clay? And do you see that as something that is rigid or something that can be molded? So if you make that entire tower out of clay, guess what? It collapses, right? The continuity of precedent is very important. So that's predictability, being able to predict what's legal or illegal if you ever go to court. That's what precedent gives you. There's precedent, believe it or not, about how to overrule precedent. So, and I can't recite the rule, verbatim to you, but basically it has to be clearly wrong, and there has to be basically injustice is graded, and so ultimately the court has to follow precedent when overruling precedent. Otherwise, you end up creating chaos and unpredictability. And there are plenty of examples where precedent is important to overturn. And if you make it about the law, and really, when you're selecting a judicial candidate, you got to figure out whether they like cement or they like clay when it comes to it. And if precedent is very important, and that's important to you, that continuity, then you'll want to have that judge on the court. If being able to change with the times and being able to adapt and have that kind of living, breathing document attitude towards the Constitution, towards the law, then you probably want somebody that's more willing to do that. But ultimately, precedent is the foundation of our entire system of common law. And so it's very important that when we do that, it has to make sense, because that's how we get confidence in the judiciary, is when things make sense when we do it. So, and there's plenty of examples where it has made sense in the past.
So getting back to Prosecutor Ferguson, the dissent in that case specifically said that the Constitution, the United States Constitution, was colorblind. How many generations did it take before the U.S. Supreme Court would say that again? It wasn't until this year, in the decision that was announced a couple of months ago, where it said we have a colorblind Constitution. You think about the mistakes were made, the Bakke case in 1978, when they said you could treat people different in their admissions to medical programs and schools based on their race. You think about all the decisions that followed that. It took generations, literally, to get that changed before the U.S. Supreme Court would say again that our Constitution is colorblind. So, precedent is very important, but sometimes, especially when courts go out on ideological grounds, like this decision on June 11th, about losing your gun rights. It's now in clear conflict with federal constitutional law. So how long is it going to take before it's addressed by a federal court and it's overturned? How long would it take the Washington State Supreme Court? People lose their gun rights for generations? So precedent's important, but when it's clearly wrong, that's actually one of the canons. When you interpret it, when it's clearly wrong. Because sometimes when you're interpreting something, you can get it wrong. And you have to go back to first principles. That's why the Washington State Constitution in Article 1 specifically says frequent recurrence to fundamental principles. That's in our state constitution. Because they understood when they drafted the Constitution that you had to go back to first principles every now and then. And so sometimes we have to go back to first principles and decide that the precedent was wrong. But generally, you want to follow precedent because judges, Supreme Courts have considered something thoroughly, and it's settled law. But when the courts become ideological, then you have to go back to first principles.
Well, we're a little over time now, so we're gonna do this. We're gonna take about a 5-minute break here to use restrooms, and because I've got a whole bunch of questions here, and there's a couple of possibilities where we can see how much longer these gentlemen can stay and ask a few more questions. And if they can't, then that's fine. But we're going to just take a little break to use restrooms, and then we'll come back and we'll go as much longer as we can. I want to, whether if you're, some of you are going to leave now, I just want to say, and we also want to give these folks each a couple minutes to wrap things up about their campaigns. But I want to thank Gene for putting this on. It's a lot of work, and I know it was mentioned here by Judge Larson that one time he worked for Dick Jensen, and I know many of you know Beth Jensen. Dick was her father. And one time it was Jensen and Jensen. I don't know if you worked with them. So we'll take a minute break now for 5 or 10 minutes, and then we'll be back and we'll see what further.
Hot right here.
way to do the conversations afterwards. Thank you so much, Bryan.
Okay, so, everyone please have a seat. slows it down. So, very next, we're gonna give, it's only about 15 minutes, we're gonna give each candidates 2 minutes, we're gonna time this gentleman. It's a little bit of a wrap. And then I know Jane wants to address everybody one more time. So with that, I guess I'll start with Judge Stevens.
So I think it's important to look at who is endorsing people. So I'm endorsed by law enforcement. I was very proud to get that. They want somebody who will actually enforce the law. That's what they told me. Also, public defenders are supporting me, prosecutors are supporting me, tribes are supporting me. Because tribes have a real problem with the state infringing upon their laws and their jurisdictions. So those are the people supporting me. Please go to our website, judgestevens4law.com, FORWA.com. And if you want to see what we're doing day to day, I updated, like we put that we went here and we'll put photos up here. You can go to my Facebook, Judge Stevens for Washington State Supreme Court, and you can see periodic updates as to what we're doing. Thank you.
So, as I've indicated earlier, we're so interested in getting that way we've lost her. And the courts are supposed to be that beacon that gets us to where we don't have these kind of, where the courts aren't looked to, number one, to create public policy, and number two, to resolve debates in society. And we have to stop doing that. The thing I bring to this court is 23 years as a trial lawyer, 18 years as a trial judge, 16 years running a court, 17 years of working successfully with the legislature to change laws and to actually get funding for courts, 10 years teaching other judges, and none of my opponents come anywhere near that. And so ultimately, I want that court to be something that's the envy of the nation. And I'm also supported by a number of some of the same folks that Judge Stevens is supported by. But the main people I'm doing this for are people like my parents. My dad watched film in my house to remind me this is for the people who just want to live love. Thanks.
Yeah, I've got kind of a slow start to my campaign, so I'm really working at getting it up and running at this point right now and getting a presence online. I do have Facebook, just got set up recently, I think, and working on getting the word out and getting better organized. Going up against the Chief Justice, she's really got her supporters, her endorsements and all that. I would welcome endorsements, and I will probably seek endorsements. I'll probably be approaching the same folks that have been behind some of our counterparts. And I certainly appreciate your support as the voters and the public. And you'll certainly be seeing more. There's a lot on me on the search as it is right now, so you can find me online. But I certainly appreciate the opportunity today to get in front of you all, to give you a better feel and understanding of where I am and I'm coming from as a candidate, and what my thoughts are on how our Supreme Court should look on a going forward basis. Thank you.
You all got under the 2 minutes, that's great. Jane?
Thank you so much. Didn't our candidates all do a good job today? Sorry about the technical difficulties. say right now that the campaigns are, they need your support. Judges can't ask for money.
Oh, we got
Again,
to move around. They got to step out.
Okay, you step out of the room.
I have to go to Black Diamond, so it's been great. Yeah,
Okay.
Thanks. We got to leave.
All right. So they can't ask for money, but I can. And campaigns all take money to run. They have yard signs, they have materials, they have to do mailers, they have to hire staff. They need your support. And if everybody, even those on Facebook, can give to these candidates, the 4 state Supreme Court justices that I invited today, we have all been vetted, and they support your constitutional rights. And this is really important. I guarantee you none of these guys are on speed dial with Bob Ferguson. Unlike the ones that are in there now. So I have envelopes back there. I want you guys to give in to Bryan and the 4 justices that were invited today. And please, whatever you can do, give them something. This again is the most important race. We have a chance to overturn 5 seats, 4 of them in the primary. And I need you guys to have all of your friends know the importance of voting in the primary. Last year, only 23% of the people in our state voted in the primary. So we lost all good candidates last year because people don't vote. The general, only 37% voted.
Wow.
So we need your vote. In the back of the room, I have a list of, and I had to go to a smaller font, all the anti-gun bills that have been passed since 2019. And every one of these have been brought to court, and we win in the lower court, get overturned without even hearing our side in the state Supreme Court. So that's why the position is so important. I wanted to thank Bryan so much for helping out today. And the other candidates, someone can let them back in the room. I'm not asking for money, but their envelopes are back there. But thank you for running a little long today. This is our first time using this building. I really want to thank the building owners. They are strong supporters of these constitutional candidates and judges and things like that. They have given me an office on the other side of the building to do all my volunteer training and all that. So I appreciate you guys going through the speaker static today. That I wanted to thank Todd McKellips, who's a real good volunteer and friend who loaned his speaker equipment. He used to be a disc jockey, but now he builds small homes. The 27th District Republicans donated money for your flyers, the handouts. Did you like those where you can write notes on it?
Yeah.
Yeah. And so I appreciate them donating for that printing and some of the snacks. And the Virginia Taylor Club donated volunteers, and they were here all day yesterday. We were here from noon till nearly 7 p.m. working on this room. And Tacoma history comes alive. Patty Mooney, she had a little table back there. She had to leave to another appointment. But she's going to do a history of the Freight House Square. The building, the reason why you see peeling paint and some stuff like that is because through eminent domain, they have to give up this historic building to Sound Transit. And so it's all going to be torn down, and it will become like the middle of this building.
Boo!
So, and then since I do have an office here, I've offered all these candidates that I will have their materials and signs here, and so if anybody needs them, they'll be right here, and you can get a hold of me. So I do want to thank also all the volunteers that spent all the hours here yesterday. They did a great job. group of volunteers that help, not only with this event, but outreaching to churches and firearm owners and things like that. So with that, I really appreciate all of you coming. This will be on Facebook Live. Thank you to all the Facebook listeners. It's on Washington Women's Rights for Firearm Ownership, and if you don't remember that, you can ask me. It will stay on Facebook for 30 days, but then it will also be posted on Christian Outreach Washington's YouTube page. And so please like that page. The more people that like it, I'll be able to live stream on YouTube. So sorry, I'm not putting my back on you guys, but it seems like if I stand like this, there's no static. So thank you so much for coming today, and I appreciate all of you guys, and have a great afternoon, and we'll be doing more events here, so thank you so much.
Okay, I need to find the other one then. I need to find it. Now I will be here. Now I'm going to find it. Yep, Monday's the finale. Yeah. For public comment. So dumb, isn't it? I think they tried to